All right, file item 8, which is AB 436, Assemblymember Jones. Good. I think Senator Leno liked that bill. Good afternoon, Assemblymember Jones. We're on file item 8.
Thank you, Madam Chair and Senators. Assembly Bill 436 will clarify that attorneys appointed by the court to represent conservatees in dementia powers cases are to be discharged by the court or ordered to continue representation upon the granting or denial of those powers. Currently, the law provides a process whereby conservators can be granted extraordinary powers over the conservatees suffering from dementia, including the authority to administer psychotropic medications and to move the conservatee to a secure facility. These powers can be granted only after investigation and court hearing, at which the conservatee is represented by counsel. If the conservatee cannot retain counsel for any reason, counsel will be appointed by the court. The law is unclear as to the status of these court-appointed attorneys once the hearing has been held and the dementia powers granted or refused. By voting aye for AB 436 will ensure court-appointed attorneys have a definitive end date when appointed to conservatees. A lot of conservatees in here. This bill is sponsored by the Conference of California Bar Associations and supported by the Trust and Estates section of the State Bar of California. I thank you for your aye vote, and Larry Doyle is here to testify on behalf of the bill if there are any questions.
Thank you. Mr. Doyle.
Thank you, Madam Chair, members. Larry Doyle on behalf of the Conference of California Bar Associations with the sponsor of the bill. This bill simply provides certainty at the request of a working group of attorneys and judges from San Diego who wanted to know exactly what the status would be when dementia powers are granted or denied. This specifies that the court must tell them where they stand. It's a good idea, and we ask for your aye vote.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? Good afternoon.
Good afternoon, Senators. I'm Richard Calhoun with Cedar. We are here today opposed to this motion.
And what is your affiliation?
Cedar, Coalition of Elder and Dependent Adult Rights.
Thank you. I apologize.
We are opposed to this, and first I'd like to start by pointing out there appears to be an oversight in the description on the analysis today. It appears to have omitted the word secured in front of the word facility. The way it reads right now, it just says placed in a residential facility, and I think the word secured is critical to be put back in there, if this bill passes. Cedar strongly agrees that there is widespread confusion on what court-appointed attorneys are supposed to be doing. The reason for that is the court-appointed attorneys, for whatever reason, decide that they don't need to follow Business and Professional Codes 6418. And that was passed back in 2000 as a Consumer Protection Act. That bill basically requires you to have a written fee agreement. Every attorney is required to have it. That bill requires them to enter into a written agreement and provide a copy to the client or the client's legal guardian or representative. If they did that, they could do what the bill says, disclose their hourly rate, disclose what charges are going to be applied, discuss the nature of the legal services to be provided, which could include when they start and when they terminate, and the respective responsibilities of the attorney and the client. If they simply followed existing law, we wouldn't have the confusion. Back in 2014, a public records request went out to all 58 counties. About 6 counties had contracts with their court-appointed attorneys. Then we did a rule 10-500 to 58 superior courts. One county, San Francisco, had a written contract with their court-appointed attorneys. The vast majority of court-appointed attorneys have no written contract. As a person that has gone through the probate system, my county I was involved in has a website. It says that the court-appointed attorneys charge $60 an hour. We had the privilege of paying a fee of $350 an hour. They don't follow the existing rules. This covers up a problem. We need to address the problem. They should have followed existing law. They could ask a judge, are you dismissing me? do I need to continue? They're already in the court. There's no need for this. It's superfluous, and they need to go back and address existing law, and that's our point. And I'd also like to point out, I don't believe that we're a stand-our alone. I know our opposition came in at the last minute, but maybe the committee could ask staff for update on how many organizations and people are opposed to 436. Thank you.
Thank you very much. Mr. Doyle, would you like to respond? As I understand the objection, it's that even court-appointed attorneys, which is what this addresses, should have written fee agreements, I'm assuming not with the client, because in most cases the client suffers dementia and is arguably unable to contract, but that there should be a fee agreement with the various courts for court-appointed conservatorship counsel, and that there isn't, and therefore that should be what we're focusing on rather than allowing court-appointed attorneys who do not have written fee agreements to be able to move the court to be dismissed and otherwise relieved of their responsibilities or ordered to continue them. Is that?
I think that that's basically it, and I think it goes with the idea that in this case, the client, the AB or Business Professions Code 6148 is a consumer protection measure designed to make sure that the person who contracts with an attorney knows what they're getting into. It requires that the attorney provide a contract to the consumer to stating hourly rate and what's going on and all the rest of these things. The problem here, of course, is that the client, as it is the court. The court is the one who sets the terms of the representation. The court does not need to be protected from the attorney overcharging because the court has the right, complete and total right, to accept or deny any expenses that the attorney places before the court. The attorney will calculate up his or her expenses, and the court will either accept or reject those expenses as unreasonable, and they will have to go on. In this case, there may be, it could very well be that that this process could benefit from greater transparency if there is indeed confusion or evidence of problems in this process. This bill does not address that. This bill addresses a very specific, narrow problem of the question of what happens after dementia powers have been granted or denied, and at that point in time, it's not about how much the attorney is charging, it's about whether or not the attorney is to continue to, to monitor what is going on and to file a report, in which case they can be accused of trying to line their pockets by overcharging, or whether the attorney assumes that they have been discharged, in which case they may be vulnerable to accusations that they have violated their ethical duties because they, sort of dropped the ball and nothing else has happened there, and they could be subject to discipline by the state bar or malpractice action. So that's what this bill addresses, not the larger issue of transparency in the court-appointed attorney process.
Thank you. Any other questions? Senator Wojtkowski.
You're still going to have to file a motion to be dismissed, right? I mean, if you have the dementia hearing, this certainly clarifies that it's an appropriate time to consider it, but the mechanism, when you get on a court-appointed case, you go there and the court says, well, you'll accept the appointment. I order you as appointed to work with this conservatee. So are you anticipating with this, the legislation that the trigger is going to be that now people are going to be clear that this is an appropriate time to do a motion to be dismissed?
I believe so, and it's, that may go a little bit beyond my expertise, but what it seems to be is that in this case, you would be holding at the time that the powers have been granted after the consideration of everything that goes in, and dementia powers are, like a huge deal because you're talking about somebody having the right to put somebody in a secure facility and to force feed them psychotropic medication and pretty much forever, because it's not like an LPS conservatorship where it's under subject to annual review. So at that time, the court will make the award. And at that time, it seems appropriate that the court make a decision as to whether or not this is ongoing or something else, rather than, as you're suggesting, that the attorney then need to come back, hold a separate hearing, which involves time, effort, and everything else, to do it, to say, okay, am I dismissed? And I think that that's what's happening now, and it seems to be kind of a waste of the court's time and the attorney's time and everybody's time, and not to mention additional money that would be coming out of the conservative's pocket under these circumstances. So, this is a better way, we think.
Right, and if the court felt that there was additional legal services that the attorney needed to do before the dismissal order would be effective, they could put that on the record, and that would be clear.
Exactly.
All right.
Thank you. Any other witnesses in opposition? I appreciate the comments of the opposition. Let me just throw out there, this is clearly not this bill, but perhaps a legitimate question is those who serve on the conservatorship court-appointed counsel, perhaps there might be some discussion about the courts actually having a contract with those attorneys so that it's, or even the court could prepare such a thing so that there is greater clarity. I just throw that out as something to consider, possibly based upon the suggestions. But understand this bill deals with what is today and seems to make sense. So are there any other questions? A motion by Senator Morlock. The motion is due pass to the Senate floor. Mr. Jones, would you like to close?
Thank you, Madam Chair. Just ask for your aye vote.
Thank you very much. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye. 6-0.
6-0. That measure, we'll hold it open for the absent member, but you have your votes. Thank you very much. Appreciate
Madam Chair?
it. Yes, Mr. Leno, sir.
I would like to move the consent calendar, please.
It's actually been moved and voted on.
Already do that?
We did that. You may not have been here. It happened, yes. Senator Morlock was very quick on the trigger there today. And as soon as we, at the end of the hearing, we will call the consent calendar once more.
I'm afraid I was here.
You were here. You haven't had much going on, though, so I don't understand the problem. All right, we will go to file item 9, AB 560 by Assembly Member Gomez. Good afternoon.
Good afternoon, Chair and Senators. Let me begin by accepting the suggested technical amendments listed in the committee analysis under item 4. I also want to thank the Chair for her early efforts in protecting our vulnerable population with the employment and housing law as a co-author of SB 1818 in 2002, and Senator Hertzberg for his support of the measure. AB 560 confirms existing law that SB 18 meant to include children. It wasn't explicitly stated, and that's what we are doing with AB 560. By prohibiting the consideration of a child's immigration status when the child is seeking recovery, we are stating our support for undocumented children who deserve the same protections as any other child and undocumented employee. Undocumented employees in California have similar protections when seeking access to the rights and remedies available to documented employees, which was codified under SB 1818. Our state has led the way in protecting the rights of undocumented children, and we must continue to do so with the passage of AB 560. Here to speak on the bill, I have a few witnesses.
Thank you. First witness.
Good afternoon, committee chair and members. My name is Jorge Castillo, and I'm a staff attorney with the Mexican American Legal Defense and Educational Fund, or MALDEF. For over 45 years, MALDEF has worked to preserve Latino civil rights in the United States and in this state. As immigrants are an ever-growing portion of our nation's schools and workforce, MALDEF has placed a high priority on ensuring equal access to judicial proceedings. We are here today because although the courthouse doors in California are open to immigrants and citizens alike, as a practical matter, the access can be undermined when defense tactics use a party's immigrant status to deter the pursuit of fair judicial redress. California dealt with this already by enacting SB 1818 in 2012, a bill that protects California workers from irrelevant and prejudicial inquiries into immigration status with certain exceptions. Recent litigation has made it clear, however, that we must do more to protect the most vulnerable members of our community. As you probably know, the Los Angeles Unified School District recently argued that tortfeasors, including intentional violators who chose their minor victims, are entitled to reduce the amount of damages a sexually abused child is entitled to recover based on that child's immigration status. As a legal matter, this position makes an assumption that is directly at odds with the U.S. Supreme Court's ruling in Playa v. Doe, which acknowledged, and this is a quote, "A state cannot realistically determine with any particular certainty whether an undocumented child will in fact be deported until after deportation proceedings have been completed." In other words, an unauthorized immigration status of a child is not necessarily indicative of whether that child will actually be deported. And the recent DACA program, Deferred Action for Childhood Arrivals, bears this out in a very concrete way. The youths there who are not otherwise lawfully allowed to be here are given immigration relief and allowed to live and work here. What is more, as a matter of policy, no child should ever be led to understand that California courts value her future less than other children. The board of LAUSD rightly directed its counsel to withdraw that regrettable position, but it nonetheless exposed this issue. AB 560 would rectify this loophole and would send a strong message that the state does not condone the notion that some children's lives and health matter less than others. California depends on developing the full potential of every child, regardless of their current or former immigration status. And for that reason, on behalf of MALDEF, we urge you to vote aye.
Thank you, sir. Next witness.
Good afternoon, Madam Chair and members. My name is Noemi Esparza. I'm an attorney at Dreyer, Babbage, Bucola, Wood, Campora, and I am here on behalf of Consumer Attorneys of California in great support of this bill. This is a huge issue that we are in constantly dealing with, where a person who commits a wrongful or negligent act and as a result, a person suffers harms and losses, they think that because this person is an immigrant or has a brown face, that they get a discount and that they can compensate them differently than anybody else. And this bill addresses that issue and states that you can't do that and you shouldn't do that. And we actually hope that this opens up the discussions for further protections for everybody, not just minors, because this is an issue that comes up all the time. So we greatly urge your support for this bill.
Thank you very much. Other witnesses in support?
Rebecca Gonzalez, National Association of Social Workers, California Chapter, in strong support.
Thank you.
Joe Michael for Equality California, also in support. Thank you.
Thank you. Other witnesses in support? Are there any witnesses in opposition? All right. Senator Wajkowski, and then followed by Senator Monning.
I have just a concern with the word irrelevant in here. I mean, I think in the law, I can understand that it would be inadmissible because we're used to evidence, and it can certainly be offensive. I get that, but because it's usually too prejudicial, we use the word, this information is irrelevant. And I'm not clever enough to figure out how it would be relevant, but I'm just wondering why we're using that rather than inadmissible in the court proceeding.
I have a guess, but I'm going to leave it to the experts. Go ahead.
I don't expect to speak for everyone's behalf, but at least from my perspective, the importance of the relevance or irrelevance is that's the standard for evidence in California courts. Irrelevant evidence is not discoverable, it's not admissible, and we don't see how it is relevant, especially in light of the fact of the guidance we have from the Supreme Court on how we're supposed to look into the future and expect to understand where an undocumented minor is going to, whether they're going to be here and be able to work in the future. I think that's not a relevant inquiry because it's not understandable.
I'd also like to add that these issues come up from the outset, even pre-litigation. And so when we talk about whether they're relevant or not, we get the defense tactic is immediately to try to discover these issues that are not even should not even be at issue at all. So instead of waiting till trial to argue that they're not admissible, we need to start early on and say that they're not relevant. You don't get to get that information in discovery because it's not even at issue and shouldn't be. And once they get this information, they use that to to obviously minimize the damages and play to the biases of whoever's involved. I mean, not even before the juries, the arbitrator, the mediator, whoever it is, to minimize the value of the case.
You get off the tort, you get off the actionable, the actions that have occurred. All right, okay.
Thank you. Senator Monning.
Yeah, thank you, Anna. Thank you for bringing this forward. I've represented workers, including children, where both in discovery and in hearings, immigration status is made an issue where it has no relevancy or bearing on the rights of that victim. A question I have, clearly this goes to the protection of tort rights of a minor. In my experience, minors are represented by a guardian ad litem. Is there any consideration, would this protection extend to the guardian as well, if there were an inquiry about the guardian's status?
I don't believe that that would really become an issue because the guardian isn't the person that's seeking the recovery, and therefore that would not even come in at all. It's going to be about the minor and what their status is because the guardian wouldn't have any stake in it.
The minor's the one with the standing for
exactly
recovery. But in terms of the potential prejudice that an attorney could try to sow with a jury that is reviewing the claim of the minor, they could try to prejudice the minor's claim by asking the guardian to come to the stand and start pursuing a line of questioning about their immigration status. But anyway, and that's not the focus of this bill, although in trying to protect the minor claimant from being the victim of irrelevant information and prejudice, my concern is just that there not be some collateral damage done by going after the status of the guardian. So maybe just something to think about.
And I would,
move forward.
in response to, I just would like to add the consumer attorneys are really hoping that this opens up that discussion. And we think that this is an important first step. And because, as you stated, there are, it just doesn't stop with minors, but we believe this is at least the first step to take.
Right. In the most extreme cases, there will be intentional informing of immigration services to try to initiate deportation proceedings in the middle of other litigation, and been involved in cases there where you have to go to federal court and get relief so that the claimants, plural, aren't facing deportation proceedings as a way to interrupt their pursuit of a legal claim for damages that happened at a workplace. So thank you for bringing this forward. Thank you, Madam Chair.
And clearly, if the federal government would act, a lot of what we have to do here, you know, sort of the yin and the yang would be resolved, and we wouldn't have to be doing so much of this. But I appreciate your explanations, and I think I would have guessed that. So I'm glad I'm still not that rusty with my legal skills. Maybe I am, but thank you very much. Any other questions? All right. Motion by Senator Monning. Assemblymember Gomez, would you like to close?
Just ask for your aye vote.
All righty. The motion is to pass as amended to the Senate floor. Those amendments were accepted? Okay,
Yeah.
very good. Thank you, sir. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, no. Anderson? Anderson, no. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye. 4-2.
4-2, we'll leave that on call. Thank you very much.
Thank you so much.
Next item is file item 10 by Assemblymember Eggman, AB 830. Would you like some water?
I'm choking to the
There is some water on the table, if you would.
It'll encourage me not to talk so much.
Your call, your bill.
Okay, thank
Go
you
ahead.
very much. It's very nice to be here before you today and present AB 830. It's a bill that makes clear that all Californians, including transgender men and women, are afforded the same protections against threat or violence based on gender. I'd like to thank the committee for your hard work on this, and we will be accepting the amendments as listed in the, as author amendments. We've all heard the sobering statistics of women being victims of stalking, threats, violence. These problems are often particularly pronounced in the LGBT community. Against transgender women in particular face extraordinary challenges in their daily lives. Transgender women of color, in particular, face even tougher challenges. There have been 11 transgender women killed this year, with an untold amount of transgender women who have been subject to violence and threats of violence. Another study shows 64% of transgender people have experienced sexual assault in their lifetime. Civil Code Section 52.4 was originally enacted by Senator, now then Assemblymember Hannah Beth Jackson in 2002 as a means to curb violence and sexual assault against women. However, it is unclear, as the law is currently written, if the same protection extends to transgender men and women. So AB 830 seeks to clarify this discrepancy by conforming the definition of gender with the Unruh Civil Rights Act. While we have made notable progress in the LGBT rights, we can't ignore the continuing plight of transgender men and women in our community. A broad coalition of support, including AFSCME, Equality California, Women's Law Center, National Association of Social Workers, and there is no registered opposition, and I respectfully ask your aye vote.
Thank you very much. Witnesses in support.
Larry Doyle on behalf of the Conference of California Bar Associations. We're the sponsors of the bill. One key element is that this bill avoids a trap for the unwary because right now, a couple of years ago, in 2011, Speaker Atkins had a bill which changed the definition of gender, clarified it throughout a number of sections of the code, something like 15 or 20, to specify that it also gender involved gender identity and gender expression. That, however, did not include 52.4, and it therefore, by the rules of legislative construction, wouldn't apply. And there have been some court cases which have held that the definitions in the Unruh Civil Rights Act don't port over to the Ralph Civil Rights Act and others. So this just makes clear that the same definition applies, and so somebody doesn't come forward, a transgender woman does not come forward to bring a case under this statute to find that they may be barred by some judicial interpretation. So we think it's an excellent bill and ask for your aye vote.
Thank you very much. Other witnesses in support?
Joe Michael for Equality California, also in strong support.
Thank you.
Rebecca Gonzalez, National Association of Social Workers, California chapter, in support.
Thank you very much. Other witnesses in support?
Savina Tacker with the Consumer Attorneys of California in support.
Thank you. Any other witnesses in support? Any witnesses in opposition? All right, seeing and hearing none. Thank you for bringing this bill. It adds a dimension that actually back in 2002 wasn't even raised. So the world does evolve. So thank you for doing that. Yes, motion by Senator Monning moving the bill. Senator Leno, any question?
Thank you, Assemblywoman, for bringing the bill forward. And if there is the opportunity to be added as a co-author, I'd be pleased to do so.
Thank you, Senator.
Thank you.
The bill is being amended, so Senator Leno, and actually I'd love to join in as well. Senator Morlaw. Oh, I'm sorry, excuse me, Senator Monning, then Senator Morlaw.
This one I'll add on.
There's and Senator Monning would like to add on, as would Senator Wachowski.
Senator Morlock as well, great.
I think Senator Morlock has a question, so we'll go from there. Senator Morlock.
Assemblywoman Eggman, you stated some very important statistics in your remarks, but the briefing materials that I get just kind of make you assume that there's a real need. And we have an item, Madam Chair, item I think 13, that provides specific examples. So for the lay people, Madam Chair, if we could have some anecdotal stories or maybe some references to articles in a newspaper that we could look up so we can kind of appreciate when we're reading, what the issue is, because you made the case, I just didn't see that in the materials. So that would just be just a request, Madam Chair, if we could, or at least for those of us that are non-attorneys, just to get some examples of what we're fixing.
All right, well, I think that the legal counsel, or the legal advocates who are in support of the bill could probably provide some of that information. And these things, you know, sometimes it's, you don't get the filing of a lawsuit because people don't think it's applicable to them. So sometimes it's hard to find the hole in a donut. But to the extent that we can do that, I think that would be very helpful, and I appreciate that suggestion. Any other questions? All right, Ms. Eggman, you may close.
Just thank you in advance for your aye vote.
Thank you. All right, the motion is due pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? No. Anderson, no. Hertzberg? Leno? Leno, aye. Monning? Aye. Monning, aye. Wykowski? Aye. Wykowski, aye. 6 to 1. 5 to 1. 5 to 1. We'll keep that on Paul.
Thank you all very much.
Thank you very much, Assembly Member. All right.